not on LinkedIn, just YouTube and Twitch. So let's see. I am going to be sharing an article because a really good question came up today about the jab and can employees actually ask about it in your jab status. Obviously, I'm saying jab because there's a little censorship going on with YouTube, which I'm going to abide by. Okay, so this article by SHRM, SHRM is the Society for Human Resource Management. They're kind of like the Bible for HR professionals or whatever religious text that you that you kind of ascribe to. It's kind of the go-to for a lot of HR professionals. So I want to see what their guidance is on the jab and what employers can and cannot do and what they're seeing, because this is a collection of HR professionals across the country. And so I want to see what they have to say. So that's why I'm back on here, because I figured why not just dig in while on YouTube, since I'm going to do this anyway. All right, so let me check this off and let's see what they're saying. So there's a couple of different articles. One is consider these steps when asking employees about jab status. The other is employees react to workers who refuse jab as the cough cough cases arise. It's so crazy that we have to do all this funky stuff to get to what we're trying to say. And then the last one was actually presented earlier in the year. And in this article, they were basically kind of against asking, but then that has, changed as federal regulations have come out. So let me share this article and pull it up. Hopefully you can see. And now I'm at the bottom of the screen, if you can still see me. All right, so this article is titled, Consider These Steps When Asking Employees About Jab Status. So we got that nice image there, and we're gonna go through here with this article. So they're saying, as the cough cough Delta variant spreads, many employers are requiring workers to show proof of their status or wear masks and submit to regular testing. Employment law attorneys recommend that businesses carefully craft that jab policies, and they caution employers not to ask for too much information. The U.S. Centers for Disease Control, better known as the CDC, and many state public health authorities have recently relaxed these safety rules and recommendations for fully jabbed people. But the highly transmissible Delta variant has caused a surge in cases, which we very well know. This was put out August 9th, I believe. This was when this was written, prompting the CDC and other agencies to recommend that fully jabbed people wear masks in certain indoor settings. Additionally, in response to the spike in cases, the federal government, and some state and local governments are requiring certain public employees, and they go into further detail about what a public employee is. I'm assuming that is someone that directly faces the public. Hello, Edward. Thank you. Welcome in, my moderator. I didn't schedule this one, so I don't think too many people will come in here today. And so it might be just two of us. So they're saying that as well as those that work in healthcare and other high-risk settings. So that's kind of open-ended, though. What qualifies as a high-risk setting? Is it just, could a store be a high-risk setting because you're interacting with people closely, right? Or is it a healthcare institution? To show proof or submit to weekly testing, wear masks, and keep physically distant from other workers and visitors. Many companies recently announced similar policies, and we know some of those companies. It's interesting that some companies like Delta, the airlines, they decided to pull things back. And I think it's because they realized that in the grand scheme of things, what's more important to them, right? And that they would prefer people voluntarily do something versus saying you have to. That's what I see with Delta, the company, not the variant. So many companies recently announced similar policies and said they plan to require all employees to get inoculated. Businesses that require it or have different policies based on status will need to balance workplace safety policies and employee privacy considerations. Here are some tips for employers that decide to ask workers for proof of their status. So they're getting into what are some limitations around this. Employers may have legitimate business reasons to ask employees about their status, but employers should be careful not to dig too deep into any inquiry. This is said by Hannah Swice, pronunciation, an attorney with Fisher Phillips in Woodland Hills, California. Stephen Riga, an attorney with Ogletree. Oh, I know Ogletree. We used Ogletree at a former company in Indianapolis, explained that employers should avoid making medical inquiries that could run afoul of the Americans with Disability Act, ADA, which is what we were getting into earlier today when I had the conversation about what employers cannot ask. You can't ask, a lot of these really stem with this act. They want to protect people that are disabled. And so as a part of that, this person is saying, put some caution around what you're asking people. So he noted, however, that simply asking for proof of inoculation is permissible under the ADA because it is not likely to prompt the employee to provide disability-related information. The U.S. Equal Employment Opportunity Commission, or the EEOC, is the protector for everyone, right? The EEOC is the protector of the people. It is for job seekers, employees. I think anyone that is either working for a company or on the job search to work at a company should be very familiar, if you are in the United States, with the Equal Employment Opportunity Commission. It is very important to understand your rights as an employee and as a job seeker. Okay, just a side note there. Okay, so the US EEOC said employees may decline to confirm their status. Let me bring myself up for that one. Employees may decline to tell their status. Okay. All right, let's go back to our article. I just want to make sure we saw that. We saw that, right? You can decline, is what they're saying. Let me take the audio off and I'll bring it back up. And hey, someone did come in here, so it's not just me and Edward. Hey, 100 rounds. How are you? How is life? Okay, so bringing this back up. Hopefully I'm still somewhere on the screen. Hoping. Okay, so the EEOC, again, this is the protector of the people, said employees may decline. Now they're saying employees, not job seeker. Employees may decline to confirm their status for reasons that are unrelated to a disability. So they're quoting, therefore, requesting documentation or other confirmation by a third party in the community, such as a pharmacy or doctor, is not a disability-related inquiry under the ADA. And the ADA's rules about such inquiries do not apply. So essentially the EEOC said you can ask about status, but employers should refrain from asking follow-up questions about why an employee did not receive inoculation, right? Such inquiries may elicit disability-related information, according to the EEOC, and will be subject to the ADA's requirement that questions job-related and consistent with business necessity. And this gets back into the conversation we had earlier. The questions asked during an interview, questions regarding existing employees, it all should come back to whether you can essentially do the job. It has to be job-related and consistent with business necessity. They also, I'm going to add in here too, it should be consistent. You shouldn't be asking one person something that's job related, but then you're not asking another person something, right? If employers ask workers to provide proof from a pharmacy or healthcare provider They may want to warn the employee not to provide any medical information as part of the proof in order to avoid implicating the ADA. This is said by the EEOC, again, the protector of the people. Mr. 100 Round said, "You're good." Glad to hear that. Okay, so Jason Habitsky, again, pronunciation, an attorney with Haynes and Boone in New York City, suggested that employers ask only for the bare minimum of supporting documentation, such as a card or a survey response. Riga noted that employers should check applicable state law too. That gets into this is why I couldn't really answer that question earlier, because there's a federal mandate, right, around things. There's company requirements. The mandate is dependent on the company, how many employees, for example. And then we also have, for example, the state of Texas saying, nope, doesn't apply here. We're going to make it illegal for you to do X, Y, and Z. So it gets really sticky. Of course, everything is typically sticky. Why would it be easy? Like, why? Of course, it's not easy. Can't be straightforward. Okay, so Riga noted that employers should check applicable state law too, which may differ from federal rules and guidelines. Additionally, if employees are requiring workers to get inoculated, they will need to consider reasonable accommodations for employees with disability-related or sincerely held religious objections. All right, and now we get into maintaining confidentiality. I don't know if you can see this. I might just read it. Can you guys see this? Edward says confusing. Oh, what is the life of HR and employment law? Confusing is definitely it. All right, so let's get into the maintaining confidentiality. The EEOC explained that any documentation or other confirmation that employees provide about their status is considered medical information and must be kept confidential. That makes sense. So everybody in the company shouldn't be like, oh, so, Ryan over here, he's got it. Edward over here doesn't have it. I'm going to stay away from them. And then that person, so it avoids any of that because, you can't. With medical records, we actually, as HR professionals, we have to keep medical information away from your regular file. So that totally makes sense. All right. So it says, moreover, data could be protected under state law. So I said employers that are subject to the California Consumer Privacy Act should be aware that collecting such information likely triggers the law's notice requirements. So employers should ensure they have issued this notice when collecting related information. Alexa Miller, an attorney with I don't know how to pronounce that, Fair Drinker. This is in New Jersey, said the best way to address employee privacy concerns is to communicate that such records will be strictly confidential and will not be used to make employment decisions. Interesting. So the last piece here, and I'll bring myself up and I'll just read it. So this last piece in here says, keep policies updated. This is a rapidly changing environment. To my point earlier and why I didn't want to stay. I was like, look, just last week, Texas said, nope, we're not doing it. So it's really sticky. So it's a rapidly changing environment, Riga said. Federal, state, and local authorities are adjusting their requirements, cough requirements, I can't say the word, regularly, which can have an impact on the business reasons why an employer might need to know an employee's status. Be sure to keep up with the rules in your jurisdiction, if I can say that word. He said, establish a process for tracking statuses and train your team to make sure you're not making inquiries beyond what is necessary. Employers will find it hard to have fixed policies and practices as the pandemic plays out. He said, so they need to be nimble and remain nimble. Swice suggests that employers create consistent messaging to communicate their processes and develop some talking points in case they are faced with questions from customers or clients about employees' status. We're still in a state of flux, says Pierce, an attorney with Morgan Lewis in Washington, D.C. So employers should continue to pay close attention to updated rules and guidelines coming from federal, state, and local agencies. So this is going to be ever changing, it sounds like. And HR professionals are just going to be going through it for a minute, trying to figure out this landscape. However, what we're seeing is that the guidance is that employers they can have a legitimate business reason to ask employees about their JAB status. However, employers should be careful not to dig too deep into an inquiry because they could be digging into some related ADA or Americans with Disability Act issues if they're prying too much, right? So they were saying that before, and then also they said it has to stay confidential, whatever the status is. An employee can elect to say they may decline to confirm their status for reasons that are unrelated to a disability, right? So that's really, really interesting. And this was written in August. So there may be some newer information that comes out of this. And I like that they did include state and local guidelines too. That's what we have to be aware of. So whatever state you're in, you need to know your whatever the guidelines are. And then again, I'm going to reiterate, definitely get to understand the EEOC, Equal Employment Opportunity Commission, because they're your friend. They are the protector for employees and job seekers. So with that, I think I'm going to close it out. Let me just take a peep at this other article and see what they have to say. So this one was titled, Employers React to Workers Who Refuse JAB as Cases Rise. So this was the newest one, August 23rd. So again, there's some accommodations. So they're saying disability accommodation. If an employee refuses to obtain inoculation, an employer needs to evaluate the risk that objection poses, particularly if an employer is mandating that employees receive an inoculation. A mandate should be job-related and consistent with business necessity under the ADA, Americans with Disabilities Act. An employer can have a workplace policy that includes a requirement that an individual shall not pose a direct threat to the health or safety of individuals in the workplace. If an inoculation requirement screens out a worker with a disability, however, the employer must show that the unjabbed employees would pose such a threat. The EEOC defines a direct threat as a significant risk of substantial harm that cannot be eliminated or reduced by reasonable accommodation. The agency said employers should evaluate 4 factors to determine whether a direct threat exists: the duration of the risk, the nature of severity of the potential harm, the likelihood that the potential harm will occur, and the imminence of the potential harm. An employee who cannot be inoculated poses a direct threat to the workplace. The employer must consider whether a reasonable accommodation can be made, such as allowing the employee to work remotely or take a leave of absence. Managers and supervisors responsible for communicating with employees about compliance with the employer's JAB requirement should know how to recognize an accommodation request from an employee with a disability and know to whom the request should be referred for considerations at the EEOC. Again, EEOC equals our friends. Employers and employees should work together to determine whether a reasonable accommodation can be made. Helen Heischkopf, an attorney for Hohet, Newman, Regal, and Kennedy in New York City, said employers should evaluate the employee's job function, whether there is an alternate job that the employee could do that would make inoculation less critical. And the third one is how important is it to the employer's operations that the employee be inoculated. So those are 3 things to consider. Now they get into religious accommodation. Hey, Victoria Slichet. Hi, Ms. Forwaller. Religious accommodation. Title VII requires an employer to accommodate an employee's sincerely held, open for determination, right? Sincerely held religious belief. practice, or observance unless it would cause an undue hardship on the business. Courts have said that an undue hardship is created by an accommodation that has more than a, I don't know what this word means, de minimis or very small cost or burden on the employer. The definition of religion is broad and protects religious beliefs and practices that may be unfamiliar to the employer. Therefore, the employer should ordinarily assume that an employee's request for a religious accommodation is based on a sincerely held religious belief, according to the EEOC. Again, EEOC is our friends. However, if an employee requests a religious accommodation and an employer is aware of facts that provide an objective basis for questioning either the religious nature or the sincerity of the particular belief, practice, or observance, the employer will be justified in requesting additional supporting information. I don't know what that means. Note from your pastor. I don't know what that exactly entails. Take that as you will. If an employee cannot get inoculated because of a disability or sincerely held religious belief, and there is no reasonable accommodation possible, an employer could exclude the employee from physically entering the workplace. Hello, remote work. Hello. Okay, so Johnny C. Taylor Jr., SHRM, SCP. The Society for Human Resource Management's president and chief executive officer. But this doesn't mean an individual can be automatically terminated. Employers will need to determine if any other rights apply under EEO laws or other federal, state, and local authorities. All right. Oh, man. Okay, the last one is terminations and heightened safety measures. Oh, let's see. Look, my battery is dying, so I may not be able to talk about this one fully, but I'm going to try. Let's try it. Ms. Perot says, always good to see you too, Edward. Good to see. Oh, hey, you guys are chatting in the chat box. Okay, cool. Thank you for being here. Appreciate it. Okay, so the last one is terminations and heightened safety measures. Many companies, including some large employers, are implementing mandates. Since the rates have stalled, the cases have spiked due to the Delta variant. In mid-June, the U.S. Centers for Disease Control and Prevention, CDC, reported an average of, so they reported an average of 12,000 new cases each day, but the rate recently surpassed 60,000 a day on average. Wow. An increase in the number of cases will put more strain on healthcare resources, lead to more hospitalizations, and potentially more deaths. This is according to the CDC. The agency said that the inoculations are the best protection against variants. In response to the uptick in cases, the federal government and some state and local governments are requiring certain public employees, again, that was noted in the past one, public employees as well as those that work in healthcare and other high-risk settings to get inoculated. So very interesting. I'll keep following this if people are interested. The laws do not say anything against encouraging or incentivizing employees to get inoculated, but there is definitely the case that they're saying here about disability accommodation. So you are protected under the ADA or Americans Disability Act. So if you're someone with a disability, you have some protections that I think you should know about. And then also religious accommodation. So that's also protections that you should know about. And so employers, they are being guided legally to ensure that they evaluate the employee's job functions, whether there is an alternative job the employee could do that would make inoculation less critical for them, and how important it is to the employer's operations that the employee be inoculated. The earlier guidance as well said they need to assess the direct threat, if there is a threat that exists, the duration of the risk, the nature and severity of the potential harm, and the likelihood that the potential harm will occur, and then the imminence of the potential harm. So how great the harm would be. So that is what the Society for Human Resource Managers has said. It's very interesting stuff here, right? Okay, I'm going to close things out. So the articles are in the link. I know I linked at least one article. So if you are interested in learning more, the About section, read it for yourself. Don't just listen to me. And then also, I am just going to reiterate, Equal Employment Opportunity Commission, the EEOC, is an employee's friend. It is a job seeker's friend. They are the ones that are putting protections into place and ensuring that companies are not discriminating against employees for any reason. So they are our friends. And I think that anyone should definitely understand the EEOC and their guidances. And when you're looking at the Society for Human Resource Management, or SHRM, they're heavily aligned with the EEOC because, look, at the end of the day, HR is also in place for companies to make sure the companies aren't getting sued because they're doing stupid stuff. Just doing stupid stuff or just doing things that they aren't even aware of. Again, like to our earlier conversation, a person could be genuinely just asking someone out of curiosity. It's not saying that you may want to discriminate against them, but those protections are in place to make sure that you don't discriminate, because there's biases in so many different ways. You know, there's conscious biases. So I see a man that is not as well dressed and I fear them because I think that they're poor or something, whatever. Or, you know, there could be an unconscious bias. So I see someone, I don't directly know that I have any biases against them, but they're in the back of my mind. And then I do something, not even realizing that it's because I have these unconscious biases underneath. So they're there to protect you. So I just recommend checking those out. Let me look at a few comments. Oh, hey. So Edward said it was confusing earlier. Definitely confusing. Definitely confusing. It's all confusing. But just know that those protections are in place. If you're in the United States, and this is the issue that I have, a lot of people don't know that they have these rights, that they have protections. And so I want more people to understand the EEOC, Americans with Disability Act, all these different protections are in place. You just have to know about them. So you have to understand that. And so the article is in the About section if you want to check it out. There are some protections in place. It's not, when you keep seeing the news and they're talking about mandates and everything, if you have a disability, if you have a religious, you know, affiliation, if you have something like that, what SHRM is saying is that you should be able to clarify that and use that and have an accommodation made for you, as long as you're not seen. Overall, the points that they were making is that you're not going to be a threat, and the employer should be making some type of accommodation. If your job doesn't have to be directly in front of people, or they can switch you to something else where it's remote, then they should be able to do that, is what I'm getting away from the article. Alrighty, yes, thank you, Miss Roller. Please do hit the like button. Share if you know someone that should have this information. Definitely share, share, share. That's the only way people find me, I think, because I don't think YouTube is trying to push out my content like that. Not this video. Not this one, guys. Always good to see you too, Edward. Hey, Sharky, I didn't see you come in here. Hello, nice to see you. Ms. Ruler said, I wish they would incentivize healthy practices. Yes, I wish they would incentivize healthy practices too. Now, some companies do incentivize healthy practices. The government, no, we're not going to get that. Come on. Government's trying to just pay your taxes. That's all we care about. That's my view. That's me, Jessica, my personal view. But yeah, I mean, I don't really think that's the government's job. Hi from the UK. Hello, Darren. Welcome in. Nice to see you. Hopefully you got something out of this video, but this is specific to the United States. I know in the UK, there are some challenges there too. So my heart is with you there. Alrighty, so I'm going to close this out. Thank you. Please do hit the like button as you leave if you haven't already. And I appreciate you being here. And again, I hope you took something away from the conversation. I will see you in the next video. Bye, guys. Or you guys know I said I'm going to try to stop saying guys. So goodbye, lovely people.